Welcome to the SQE preparation lecture series by Lex Imperium Academy. In today's lecture, we will begin studying one of the most important subjects tested in the SQE examination, contract law. Contract law forms the foundation of the commercial transaction and legal relationship in business and everyday life. A clear understanding of the contract principles is therefore essential for both legal practice and success in the SQA examination. Today we will discuss meaning and elements of a contract, offer and acceptance, third consideration for intention to create legal relations, fifth capacity to contract, sixth basic remedies for breach of contract. What is a contract? A contract is a legally binding agreement between two or more parties. For an agreement to become legally enforceable, certain elements must be present. These elements typically include offer, acceptance, consideration, intention to create legal relations, legal capacity of parties. When these elements are satisfied, the law recognize the agreements are as contract. Offer. The first step in formation of a contract is the existence of an offer. An offer is a clear explanation by one party indicating a willingness to enter into a contract on specific terms. The person who makes the offer is known as the offeree, and the person who receives the offer is known as the offeree. An offer must be communicated to the offeree and must be sufficiently certain so the terms of the proposed agreement are clear. An invitation to negotiate or an invitation to trade is not considered a legal offer. Now let's understand what is acceptance. Once an offer has been made, the next step is acceptance. Acceptance often occurs when the offeree agree to term of the offer. For acceptance to be valid, it must correspond exactly with the terms of the offer. It must be communicated to the offeree. It must be unconditional. If the offeree attempts to modify the terms of the offer, it may be considered a counter offer rather than acceptance. Consideration is another essential element of the contract formation. Consideration refers to something of value that each party gives and or promise to give in exchange for the promise of the other parties. In most contracts, consideration may take the form of payment of money, provision of goods or services, undertaking an obligation or refraining from an act. The principal underlying consideration is that a contract involved in mutual exchange, intention to create legal relation. For a contract to be legally enforceable, the parties must intend to create legal relations. In commercial agreements, courts generally presume that the parties intended that agreements to be legally binding. However, in social or domestic arrangements, the presumption may be different unless evidence suggests otherwise. Capacity to contract. Another important requirement is that the party must have the legal capacity to enter into a contract. Contained person may have limited capacity under the law. For example, minor person with mental incapacity, persons under certain legal restriction. Contract involving such individuals may not always be enforceable. Breach of contracts. A breach of contract occurs when one party fails to perform their contractual obligations. When a breach occurs, the law provides legal remedies to the injured party. These remedies may include damages, specific performance, cessation of the contract. The purpose of these remedies is to replace the injured party in the position they would have been if the contract had been properly performed. Importance for SQE examination. Contract law is a foundation component of SQE syllabus. Candidates are often tested on their understanding of contract principles and their ability to apply these principles to practical legal skills scenario. Therefore, students preparing for the SQE examination should focus on both theoretical understanding and problem-solving skills. Conclusion. To conclude, contract law governs legally binding agreements and plays a critical role in commercial and everyday transactions. Understanding the essential element of contract, including offer, acceptance, consideration, and intent to create legal relations, is crucial for legal practice and for success in the SQE examination. In the next lecture, we will continue exploring the important aspects of the contract law and other subjects, including in the SQE syllabus. So this is a basics lecture on the contract law. There are other topics now I will complete: tort law, criminal law, business law, which is the part of the SQE examination. So I'm making a demo lecture right now. Okay, so if you have any of the query, questions or anything, kindly do ask me in the comments below. I will sure be more than happy to respond to you. Okay, and if you want to join our SQE batch, so kindly WhatsApp me your details. I will help you in just joining the batch. Thank you.